Supplemental Jurisdiction short add-on for law students only. Two important things I want to lead with. One, this lesson is exclusively for law students. And two, you must first watch my supplemental jurisdiction video, which is an hour long, but I promise I make it worth your time. Now, allow me to explain. In my supplemental jurisdiction video, I dive right into 1367, which is the supplemental jurisdiction statute. But this way of doing the analysis is more geared towards bar takers. However, the analysis might look slightly different for many law students, not all law students, but many law students. Why? Because many Civ Pro professors like the analysis to include a mention of constitutional authority for supplemental jurisdiction in step 1, and then for the student to do the statutory authority analysis under 1367. So in this video, I will go over that first step, constitutional authority. The change is so slight and minuscule from the original analysis in my supplemental jurisdiction video. Both ways yield the same result. It's kind of more of a formality. You still need to watch the entire supplemental jurisdiction video, and I promise I make it worth your time. This video is an add-on to that, and it's just to explain a little wrinkle in the analysis for some law students that have a professor who likes the mention of constitutional authority as step 1. Here goes. 28 U.S. Code 1367 is the supplemental jurisdiction statute. However, your analysis is not only going to entail the statute. There are important Supreme Court cases prior to the enactment of 1367. I highly recommend that you read these cases, or at the very least, read the commercial briefs for these cases. I'm going to give you a minuscule summary of the takeaway of these cases. Bear with me because this is important. In Gibbs, in interpreting the Constitution, the Supreme Court ruled that Article 3 grants jurisdiction over entire cases, not just over the single claims that meet jurisdictional requirements. So, if the case that is properly in federal court includes a subordinate or secondary or auxiliary claim that does not meet jurisdictional requirements, that's okay, because the court has the constitutional power to hear the entire case. This means that so long as the plaintiff asserts a proper claim based on federal law, diversity, or some other federal ground, the federal court has the constitutional power to hear other piggybacked claims, so long as these other claims arise out of a common nucleus of operative fact. That is, that form part of the same case in controversy as the claim that meets jurisdictional requirements to be in federal court. So if the Supreme Court in Gibbs already ruled that a single constitutional case includes these other claims that don't meet jurisdictional requirements, why did Congress pass 1367? Well, in Aldinger, Kroger, and Finley, the Supreme Court emphasized that it was not enough that the federal courts have constitutional power to exercise supplemental jurisdiction over the piggybacked claims. These cases specifically also required statutory authority for the federal court to exercise supplemental jurisdiction. So in these cases, the Supreme Court was like, hey, Congress, we confirmed the constitutionality of supplemental jurisdiction, but many cases require statutory grant of jurisdiction. Get on it. By enacting 1367, Congress provided the necessary statutory authority to hear the related piggybacked claims. And that's a very, very simplified explanation of why and how 28 U.S.C. 1367 came about. That's how 1367 was born. And why am I telling you all this? Well, your analysis for supplemental jurisdiction will involve two sources of authorization. Article 3, Section 2 of the U.S. Constitution as interpreted by the Supreme Court in Gibbs, and the Supplemental Jurisdiction Statute, 28 U.S. Code 1367. How to do the analysis. Step 1, we're going to determine whether the federal court has constitutional power under Article 3, Section 2 to hear the supplemental claim. This step is a two-part process. We're going to ask two questions to determine this. A, does the federal court have original subject matter jurisdiction over the original lawsuit? This is telling us that there must be a claim in federal court that has independent original subject matter jurisdiction in order for the court to exercise supplemental jurisdiction over another claim. You will need to be in a scenario where there's federal subject matter jurisdiction grounded on federal question, on diversity jurisdiction, or another federal ground. Maybe you have an issue of patent or trademark law, or the U.S. government is a party. All the scenarios where the federal court has independent original subject matter jurisdiction to hear a case. This needs to be in place before even considering supplemental jurisdiction over another claim. The second question you will be asking is, does the claim you want to piggyback, the one that's lacking independent federal subject matter jurisdiction, derive from a common nucleus of operative fact as the original claim, the claim for which the court has already federal subject matter jurisdiction? I'm going to be a little persnickety about the wording because these are the magic words. I don't want you to say same transaction or occurrence. I want you to say that for a federal district court to exercise supplemental jurisdiction over a state claim, the state claim and the claims that meet jurisdictional requirements must derive from a common nucleus of operative fact. And this first step has nothing to do with 1367. This step comes from United Workers versus Gibbs. So in order to determine whether federal court has constitutional power under Article 3, Section 2, to hear the supplemental claim, we must answer, does the federal court have original subject matter jurisdiction over the lawsuit? And does the claim lacking independent federal subject matter jurisdiction derive from a common nucleus of operative fact? It is after this that you do the analysis for 28 U.S. Code 1367 the way I did it in my original supplemental jurisdiction video. Here's a visual of this alternative analysis. Also note that the drafters of 28 U.S. Code 1367 incorporated into 1367A the Gibbs test aimed at determining constitutional authority. So if step 1 here is met, then the first part of step 2 is also met. 2 birds with 1 stone, right? See here? So the analysis goes like this. If step 1 is met, then 1367A is also met. Then if there are no exclusions under 1367B and no discretionary factors under 1367C apply, then there's supplemental jurisdiction over the annexed claim, over the claim we want to piggyback. So just to be clear, after you do step 1 under Gibbs, determining there is constitutional authority, move on to the analysis of 1367 just as I presented it to you in my original supplemental jurisdiction video. And remember that if Gibbs is met, then 1367A under step 2 is also met. I hope this video was valuable to you, and if this is how you're feeling after this lecture, shoot me an email to questions@jdsimplified.com.